Hello, this is Richard Spindler back from Amend United to continue with the second video about corporations and problems with our democracy. In this video, I'd like to go over the corporate legal case history, outlining where some of our problems have emerged. The legal thought in the early 19th century was given quite well by this quote from Chief Justice Marshall, our very first Chief Justice in the United States, who, by the way, was a Federalist and quite conservative. He said, "A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, it possesses only those properties which the charter of creation confers upon it, either expressly or as incidental to its very existence. These are such as are supposed best calculated to affect the object for which it was created." This says in just a different way what Amend United and many organizations' feelings are about corporations, is that corporations are created by people through the state charter. Corporations are created by the charter through the state. They are merely creatures of the law, creatures of the people, we the people that created them. And because we created them, they only have the privileges and properties that we confer upon them. Okay? They do not have separate constitutional rights. Okay? That is essentially what Chief Justice Marshall is saying here. The early corporate charters reflected that. Corporations had a limited lifespan. For example, they were given a charter to create a railroad from point A to point B. And when they were done with that, when they finished, they were done, and the corporation was done. In addition, no corporations could own other corporations. They had a specific purpose, and they did that, and so forth. They did not like unlimited liability because of the abuses they could see when the sovereign had given his transnational, the king that is, had given his transnational corporations unlimited liability. And quite a few other things that were not allowed. For example, a board of directors could not live in a state where the corporation, they had to live in the state where the corporation did business. Quite different from now. Let's go on now to look at the 14th Amendment, and we'll see why that's important here. The 14th Amendment is really about due process and equal protection. No state shall make or enforce any law which shall abridge the privileges of citizens, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person the equal protection of the laws. The 14th Amendment was written so that freed slaves had full access to legal due process, that they had equal protection under the laws, as did citizens had always had before that in the U.S., so that the freed slaves also had equal protection. This was to guarantee, at least in theory, that they had due process upon being freed. So why is that important? In the 1870s, the railroads, which were the most powerful corporations back then, they argued that they were persons, and governments then could not regulate railroad corporation fees and activities or tax them in different ways because governments can't interfere in their lives as persons. So look at this. So here the 14th Amendment said the laws which shall abridge the privileges of citizens, nor shall any without due process of law, and so forth. So they are trying to use this 14th Amendment as persons, as citizens, to not pay taxes and so forth. And their argument, if you look at the second bullet here, was that different laws and taxes in different states and municipalities violated equal protection under the 14th Amendment. So what they had done was they repeatedly brought cases to the courts. They had a huge amount of resources, and so they would bring these to the courts. Hope maybe it would get to the Supreme Court. The Supreme Court would say no, but they repeatedly did this over and over again until they found a friendly court to rule in their favor and establish a precedent. And they had the resources to do that, which a regular citizen would not. And so that led to a watershed moment. Santa Clara County versus Southern Pacific Railroad in 1886. They again brought this argument up that the 14th Amendment applied to them, and in the end, the court it did not make a ruling on the question of corporate personhood, which is a term we tend not to use in our movement. We were talking about corporate constitutional rights. But anyhow, the decision subsequently was cited as a precedent to hold that a private corporation was a natural person that had constitutional rights. And really, what it was written in the introduction to the ruling on this case by a clerk. And back then, clerks had a fair amount of power. The corporate clerks did. And so that introduction was used by justices in the future to strike down hundreds of local, state, and federal laws that were there to protect people from corporate harm. So now corporations were citing that case that the 14th Amendment under equal protection and due process applied to them. Okay, so at that point, the railroads found a sympathetic court and a sympathetic clerk that ruled, in a sense, in their favor. The technical ruling of that case did not rely on that, but it was put in the beginning of the brief on it, citing that there was an assumption that corporations had these constitutional rights. And here's an interesting quote from Justice Black on this. Of the cases in this court in which the 14th Amendment was applied during its first 50 years after its adoption, less than 1/2% invoked it in protection of the Negro race, and more than 50% asked that its benefits be extended to corporations. So what you could see is that corporations took full advantage of this possibility of arguing that they had constitutional rights applied to them should have applied to them under the 14th Amendment. And it's interesting how little compared to them that was used for what it was originally designed for. Here's another example of corporate rights and the 14th Amendments. In this case, Liggett versus Lee, the people of Florida had passed a law that levied higher taxes on chain stores. Well, the Supreme Court overturned that because they cited due process and equal protection under the 14th Amendment. So this had real effects throughout the nation. Let's go on to other amendments in the Constitution. The Fourth Amendment right. That's a right to privacy and unreasonable search and seizure, so that police can't pull you over for anything and search you. This was instituted to prevent soldiers when the British used to do this, just burst into homes and search and seize colonist property. So this right was instituted for a good reason. But now corporations trying to argue that they have constitutional rights as some kind of natural entity are using it to avoid inspection and regulation, meaning a safety inspector can't just come in and inspect a facility. So there are a number of cases along those lines. So for example, here's one, Hale versus Henkel in 1906. They argued for search and seizure protection under this one. And in this case, this suit that the corporations brought was an attack on the Sherman Antitrust Act. The corporation in this suit argued that it had a right to privacy, and so it did not need to reveal its corporate documents in showing whether or not there were monopolistic practices going on. So really twisting and expanding the intent of the Fourth Amendment rights to corporations to prevent an inspection of their documents, which was necessary to apply the Sherman Antitrust Act. Let's look at Fifth Amendment rights. So you can see now that the thinking of corporations as having constitutional rights is gradually expanding to more rights. Originally, this was developed or created to restrain governmental abuses in the colonies. For example, you can't force a person to testify against himself or herself. You can't be tried twice. Many people know at least are familiar with the idea of takings, which limits the power of eminent domain. Meaning a local government can't just take your property and use it for whatever it wants to. And those are all valid reasons for having the Fifth Amendment rights clause. And it's considered a due process type of clause. Well, let's look at another one where corporations are using this. In Pennsylvania Coal versus Mahon, a regulation there was deemed a takings. So essentially, the argument by the company was that if a government puts a regulation on us, that is taking of is diminishing the value of our property in some way, and so the company should be compensated for that by the government. So you can imagine not only the expense, but also the bureaucracy that would be required to determine what compensations to give the companies when the government is simply regulating a company in the public interest for safety and other reasons. So this is quite an expansion of Fifth Amendment rights, giving another constitutional right to corporations. Let's go on to First Amendment rights. Here, that prohibits the making of any law that does any of these things, and many people are familiar with these. For example, freedom of speech, freedom of the press, and so forth. Well, now many corporations feel like these things should be applied to themselves as if they are natural persons with constitutional rights. So a very famous case was Buckley versus Vallejo. Here, the Supreme Court rules that political money is equivalent to speech to some extent, not completely. So it's kind of a gradual expansion of First Amendment rights to corporations. So what it did was it expanded First Amendment protections to include financial contributions to candidates or parties. In other words, thinking of money as speech. Well, then, not too much longer later, so you can see this was 1976. The next year, they expanded those Supreme Court expanded those First Amendment rights. In this case, First National Bank of Boston versus Bellotti. The First Amendment there was used to overturn state restrictions on corporate spending on political referenda. In other words, corporations could spend as much as they wanted on referenda. This reversed the court's long-standing policy of denying such rights to non-media business corporations. It was felt that historically that media needed stronger First Amendment rights so that they could call out politicians and others in various electoral situations. So this precedent is used along with the last case to thwart attempts to remove corporate money from politics. This case is quite interesting. In 1996, the effect of this was to basically say that a corporation has the right not to speak. So in this case, Vermont wanted to require the labeling on some products about the bovine growth hormone. And the corporation argued you cannot require us to speak about that under the First Amendment. And next was one that many people have now heard of, Citizens United versus FEC. This case explicitly ruled that corporations, and again, I want to emphasize all different kinds of corporations, have the same political speech rights as individuals under the First Amendment. And the quote from their ruling is really kind of astounding, saying, "We now conclude that independent expenditures, including those made by corporations, do not give rise to corruption, or the appearance of corruption." That is rather astounding, non-factual statement, I would argue. And finally, most recently in 2014, they expanded the use of First Amendment rights, and in particular, the assertion that money is speech by ending limits on candidate contributions as violating the First Amendment. So as you can see, there's been two broad corporate strategies in legal history. One is to abuse constitutional provisions as constitutional persons, as having constitutional rights freed from democratic oversight, and also equating the amount of money to speech rights because they have a lot of money, so they would like that. So basically, they're using their rights as persons to circumvent or stop many regulations and, of course, to influence electoral campaigns. So in the next video, we'll talk about Men United's and several other organizations' strategies to address this. Thank you very much.